Hello, my name is Rachel Rose, and I'm an attorney in Houston, Texas, where I've had my own law firm, Rachel V. Rose, Attorney at Law, PLLC, for over a decade. My practice primarily focuses on healthcare, cybersecurity, securities law, False Claims Act, and Dodd-Frank matters in relation to compliance, transactional, and litigation. I also teach bioethics at Baylor College of Medicine, something that I have done for the past 9 years, and I'm fortunate to be extensively published and sought after as both an expert and a presenter. Today, I am delighted to join Quimbee in bringing you Anatomy for Lawyers, Anatomy, Injuries, and Common Procedures. So no presentation is complete without a disclaimer, and the information presented here today is not meant to constitute legal advice. So you should consult your attorney for advice on a specific situation. Additionally, the information presented is current as of the initial date of this presentation, and participants are encouraged to check relevant government and other relevant websites for the most up-to-date information. So today I'm going to begin with some legal aspects related to procedural and evidentiary considerations. From there, I'll delve into medical positioning, terminology, and general terms which every lawyer should know. I'll then transition into anatomy, and specifically the framework of orthopedic anatomy and neuroanatomy, because a lot of common injuries, whether they come about in terms of medical malpractice or car or other types of accidents, or some of the class actions that are typically seen around the medical device and pharmaceutical industry, typically have a neurologic or an orthopedic component to them. I'll then wrap up and provide a conclusion. So what are some of the critical evidence and procedure considerations? Well, first and foremost, for those of you who practice in federal court, discovery in any case is absolutely paramount, and the key discovery rule of civil procedure is 26. Specifically, certain information is required to be provided to the opposing side without a discovery request. Certain items such as the name, address, telephone number of known persons with discoverable information. Additionally, initial disclosures must be made at or within 14 days after the parties Rule 26F conference. And in terms of expert testimony disclosure, in addition to the disclosures required by Rule 26A, a party must disclose to the other parties the identity of any witness it may use at trial to present evidence under Federal Rule of Evidence 702, 703, or 705. Importantly, for new lawyers, there are two types of expert witnesses. There's one which is a consultative expert and another which is a testifying expert. So it's important to appreciate that distinction, because the consultative expert does not need to be disclosed, but the testifying expert absolutely has to be disclosed. So what about expert testimony and reports? Well, Federal Rule of Evidence 702 is the fundamental rule which governs this. And here, a witness who was qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the following conditions are met: the expert's scientific, technical, or other specialized knowledge will help the trier of fact, which is typically the jury. Unless there is a bench trial, then you have the judge, who is also the trier of fact, to understand the evidence or to determine a fact in issue. The testimony is based on sufficient facts or data. The testimony is the product of reliable principles and methods, and the expert has reliably applied the principles and methods to the facts of the case. Now, if we lived in a vacuum and it was only the text of 702, then that would be easy. As many people know who are seasoned lawyers, and if you've been through law school, there are typically evidentiary rules at the state level as well, which correlate to Rule 702 under the federal rules.